All right. Now, I would like to start with you by asking, how has ECOWAS as a whole impacted on the Nigerian society and member states?
Well, thank you very much. As you stated in your intro, ECOWAS was created here in Nigeria in 1975 for the purpose of integrating the nations and the peoples of West Africa. That's the primary focus, the primary purpose for which ECOWAS was founded. So whatever ECOWAS does, that goal is always in mind, to unite and integrate the people of West Africa. To be able to assess the weight, assess the impact of ECOWAS, then we have to move into actions that have been taken or concrete steps which have been taken over the years to bring our member states closer together. In my opinion, the foremost achievement of ECOWAS over the last 40 some odd years is the free movement of people and goods within West Africa. In my opinion, that's the greatest single achievement, because as it is today, all peoples of West Africa, all citizens of member states, can cross borders and enter into member states without visas, and they are permitted to live in the member states unregulated for a period of up to 90 days. And then after that, they must regularize their stay. Part of that is the right to reside in any member state of your choice, so long you comply with the local laws and you may integrate into the society and become a member of that society. So that is, in my opinion, the largest single. But there have been other things ECOWAS has done that will impact or have impacted the region. The second thing I would say is even though ECOWAS was established for economic integration, economic purposes, but they have gone one step further. If citizens will recall, ECOWAS intervened militarily in conflicts within the region. That, for me, is the second major achievement, because by intervening, ECOWAS has brought stability to the region through its, and because of that, ECOWAS has established what we call the Good Governance Protocol. And that enjoins member states to observe tenets of good governance and democracy, so that citizens' rights and privileges can be respected and enhanced. Part of that also is the requirement of ECOWAS that no member state will be allowed to participate in activities of ECOWAS where the government of that member state comes to power by illegal means. In other words, military coups or any other means other than the constitution that will bring a government to power. That government will not be recognized in ECOWAS, and they will not have any friend within the region, so they will be isolated. So that protocol on democracy and good governance, backed by the military intervention in conflict areas, I think is the second most important impact ECOWAS has had. I may go one step further. A third one, in 2016 January, if I'm not mistaken, what they call a common external tariff came into effect. That means all member states of ECOWAS must comply with certain minimum duty and custom requirements across the borders, so that it will bring stabilization to the economies of the countries in the region, so that goods and services produced in member states are exempt from taxes within the region, and then also that those member states have a duty to impose certain amount of taxes or duty or levy on imports that come from other countries. And then those taxes that are collected are what we call community levy. And it is that community levy that member states remit to the ECOWAS Commission to support the work of ECOWAS. Each country has a duty through their respective central banks to collect that money and remit it to the Commission as their. So in other words, it is not a budgetary deduction from your country's budget. It is member states support ECOWAS by taxation, by the taxes you impose on duty coming into your country. And you collect that amount, put it into a special ECOWAS account in your central bank, and that central bank then has to remit it to the ECOWAS Commission. So in other words, the good governance aspect, the economic aspect, and the free movement of goods and services, in my opinion, are the three highlights. If I would celebrate anything about ECOWAS, in my opinion, that's what I would suggest.
Wow. All right. Now you've been the vice president of the ECOWAS court for some years. What are some of the high points in your work in the ECOWAS court that you can beat your chest to? Because now you're outgone, you're leaving, and somebody is to replace you any moment from now if he has not. What are some of the high points about the court, the ECOWAS court, that you can satisfactorily go back to Liberia and say, yes, I did this job?
All right, thank you. Let me just backtrack a bit. Now, every 4 years, the authority of heads of state meet and they rotate and assign seats on the court to respective countries. So, for example, I came on the court in 2014, June 18th. I replaced the judge who came from Ghana.
Okay.
As coming from Liberia. I have served for 4 years and I have already been replaced by a judge from Sierra Leone. In other words, the heads of state meet and apportion the seats to countries, and the countries then advertise the position in their respective countries, and lawyers and judges apply, and they are shortlisted and they are interviewed, and those successful are recommended and appointed by the heads of state. In my case, I served from 2014 June, like I said, and my term has ended. The seat has been vacated by Liberia and has been taken over by Sierra Leone. So currently, as we speak, there are new judges on the court already. So I'm sharing with you my experiences on the court, and I'm not speaking as an authority of the court now because I'm a former member of the court.
Yeah.
So I want to clear that part. I'm not speaking for the court right now.
Clear.
I'm only sharing my experiences over the last 4 years.
Yeah.
Now, coming to your question specifically, you read in your intro the mandate of the court, the kind of competencies the court has. The court can hear cases on human rights. They can hear cases on contract. They can hear cases disputes between member states. They can settle disputes between the Commission or ECOWAS institutions and its staff members. And those are the competences of the court. Now, from the time the jurisdiction of the court was expanded in 2005, and the court was given a human rights mandate, the performance of the court changed. Yeah, because prior to that 2005 supplementary protocol, the court did not have jurisdiction to hear human rights violation. It came out from a man called Afolabi. He's a Nigerian citizen. He was doing business in Benin. He was transporting goods into Nigeria. And during that period, the Nigerian government closed the border between Benin and Nigeria. And the man's goods got damaged. And he sued. When he sued the Nigerian government, the defense was, this court cannot hear the case. And so the court agreed with the Nigerian government and dismissed the man's case. But because of that dismissal, Mr. Afolabi lost the case, but his case gave rise to the amendment to the ECOWAS Court's protocol. And therefore, in 2005, the heads of state extended the mandate of the court to include human rights violations. And since that extension of the mandate, I can venture to say maybe 90 or 95% of the cases that have come to the court have been violation of human rights complaints. And that accounts for why the court has been so active since 2005. Because from the time it came into being in 2001 until 2005, the court could not boast of more than 2 or 3 cases, maximum 5. No more than that. But since 2005, when the mandate was extended to include human rights violation, the court has taken off. So we commend the heads of state for that vision and that foresight. And I will take off from that point now to talk about what the court has done, cases that the court has heard, and activities that I participated in. Like I said, the human rights mandate of the court has been its greatest success in terms of determining cases in violation of human rights. And because the court is seated here in Nigeria, and for economic reasons in terms of transport costs from member states and the rest of it, the records of the court will show that most of the complaints that have come to the court are cases against the government of Nigeria. It's not because of any other reason, but the court is situated here. And for lawyers to pay their way to come from other countries, for litigants, many of whom are poor citizens, indigent people, to pay their way to come here, to hire lawyers to come, it is more difficult. So Nigerian lawyers and institutions have taken advantage of the fact that the court is situated here and have filed more cases than any other member state. So most of the cases, it's not that the court has a beef to grind with the government of Nigeria, but the fact is that for proximity purposes, the people have taken advantage of the seat of the court being in Nigeria, and so most of the cases filed have been against the government of Nigeria. Now, the court has proudly made many decisions that the court can boast of, we the judges can boast of. One of the challenges I would go straight to facing the court is implementation of its decisions, enforcement of its judgments. How are judgments of the court respected by member states? How are those judgments to be executed by member states? This is one of the greatest challenges facing the court.
You don't have an enforcement arm.
Correct. Now,
because
yes.
Sorry, sir.
Go ahead.
I'm aware that in 2016, the ECOWAS court ruled that the federal government of Nigeria should release Dasuki from detention, and also ordered that the government pay 5 million naira damages to him. Up till this moment, that ruling has not been complied with.
Well, thank you. I will respond to this in being supported by the records. And I would hope that this will not be taken politically, but these are the facts.
Okay.
This is reality. The duty of the court is to decide cases that are brought to the court by persons aggrieved by conduct of their respective governments. Now, let me just give you a brief thing, that persons accused before the court are member states of ECOWAS. So in other words, if you have a dispute between you and another individual, another citizen, that case cannot come to the ECOWAS court. We do not have jurisdiction over individual citizens as defendants before the court. Only member states, only governments are defendants before the before the court. So individual citizens from any country can sue any government that has offended them. That let me set that straight. So in this case you have mentioned, Mr. Dasuki was arrested and charged and detained and imprisoned by the government of Nigeria for whatever reasons. Mr. Dasuki, through his lawyers, filed a complaint to the ECOWAS court for violation of his human rights. Like you said, the court made a decision adjudging that the conduct of the government of Nigeria was in violation of the human rights of Mr. Dasuki. Therefore, Mr. Dasuki should be released. That is the judgment of the court. Now, I said earlier that enforcement of the decisions of the court or respect for the decisions of the court is the greatest challenge facing the court. Now, the court does not have an enforcement mechanism. It does not have an enforcement agency. It does not have staff and hands and feet that will enforce its decisions. The job of the court is to render the decision. That's the job.
Only.
Once we have rendered that decision, our job has ended. Now, the next step there, in the protocol on the court, all member states are required to appoint a competent national authority for the purpose of enforcing decisions of the ECOWAS court, in keeping with the local laws of that country. So, in other words, just how a local court, a Nigerian court, for example, would implement a decision of the federal court here, that same mechanism is how Nigeria should enforce decisions of the ECOWAS court. So, in other words, once we have rendered that decision, we send it to the government of Nigeria, our job has ended as the court. Nigeria then, through its enforcement and mechanism, must give effect to the judgment of the ECOWAS court. In the case of the government of Nigeria, your Attorney General and Minister of Justice has been designated as the competent national authority of Nigeria to enforce decisions of the ECOWAS court.
Okay.
Now, it's left with Mr. Dasuki and his lawyers and whoever else is interested to approach the Nigerian government through the Attorney General, Minister of Justice, to give effect to the decision of the ECOWAS court. It is no longer for ECOWAS to decide what to do. We have decided already. Now, let me go one step further. The protocol on the court states that where member states fail, neglect, or refuse to respect decisions of the court, to implement, to execute, to enforce, then it becomes a political decision of the heads of state through the Council of Ministers of ECOWAS. Now, what that means, when a court renders a decision, those decisions are channeled through the ECOWAS Commission, which is the political arm of ECOWAS, to the respective member states. Now, the member state at that point is under duty by the protocol to enforce the judgment. If that member state does not do it, it is incumbent upon the heads, the Council of Ministers to then report to the heads of state that ECOWAS court rendered a decision X, and that decision has not yet been enforced. So through political means, the Council of Ministers, who is the foreign ministers, will report to the heads of state. Then the heads of state among themselves, they will sit as colleagues. Say, for example, let's use Nigeria. Say, Nigeria, there's a decision you have not enforced. What do you have to say for yourself? I mean, that would be in camera among the heads of state. At that point, the court is not a party. The court is not there. The commission is not there. It's only the heads of state. So now, in the protocol of ECOWAS, it provides that member states who disrespect the decisions of the ECOWAS court should be subjected to sanctions.
Should be subjected to sanctions.
Sanctions. Now, the nature of the sanctions, the weight of the sanctions, the type of sanctions, the implementation of the sanctions is all a political decision to be made by the heads of state. Now, so if Nigeria has not done certain things, or let me come to my own country, Liberia. If a decision is made against Liberia, and Liberia has not done what it's supposed to do, when the heads of state meet, whoever the president of the authority or heads of state will be, now in this case, as we speak today, Nigeria is the chairman of ECOWAS. So the president of Nigeria presides over ECOWAS. So the president of the authority or heads of state will say to Liberia, Mr. President of Liberia, you have a question to answer. There's a decision against your government. What have you done to implement it, to give effect? If there is not a satisfactory answer, then the other colleagues can sit down and say, Liberia, we'll give you 2 months. We'll give you 6 months. If you don't comply, we'll suspend you, or we'll fine you, or we'll take whatever measure the heads of state decide. So, in short, implementation of the decisions of the ECOWAS code in my opinion, is a political decision. It is no longer a judicial function because the court has done its work and the court does not have enforcement powers. The treaty gives the member states the duty to enforce the judgment against themselves. So
now let's look at human rights. How would you rate human rights abuses in Nigeria and across West Africa? Now, when it comes to human rights, I would want to take it personal with you because from my little research, at a point in time, the Liberian government suspended your law license and you took it to court. You took it to the same ECOWAS court.
Yeah.
Can you give us a small idea how it happened and how it turned out using the ECOWAS court?
Well, thank you. I will comment on it briefly, but then I will not go into all the details. Yes, my license was suspended in 2017. Yeah, 2017.
Last year.
Yeah, February. And then
while you were serving here.
Yes, while I was serving. And therefore, then I filed a complaint with the ECOWAS court against my own government that they had taken action against me without fair hearing, without due process, meaning that they did not invite me to say, you have committed such and such offense, and therefore we are taking this action. Come and defend yourself and say what you have to say for yourself. They didn't do that. So I filed a complaint with the court and they were served. They filed a responsive pleading and over time the matter was resolved. The matter was resolved, and in short, I withdrew the matter because it was resolved. Now, but let me come to your main question, the focus on human rights. Because like I said, the human rights jurisdiction of the court has given life to the court. Almost all of the cases the court has decided are on human rights violations. And in so many member states. In fact, I would say almost all of the member states. Yes, you asked about whether the violation of human rights continues to take place. My short answer is yes. But I think I don't have statistics to prove this, but in my opinion, the violation of human rights is going down.
It's going down.
It's going down. It's reducing.
Not rising.
It's not rising. It's reducing to me. And my reason for that is the heads of state, they meet twice a year on normal circumstances in the ordinary session. Now, when they meet, they review activities of each other. They got what we call a peer review. So if something is happening in Nigeria, the president of Ivory Coast can when they assemble, just among themselves, they can say, look, colleagues, we have a situation in Nigeria we need to look at. This is it, X, Y, Z, and they discuss. So in other words, they have a mechanism to review one another's conduct. They have that ability to do it if they want to do it. Again, it is political. Because maybe in some cases they may not want to embarrass their colleague, but since it is closed door, I'm sure they do. They discuss these things and say, look, my man, you have to change. You have to improve so and so and so. So, but the reason I said it is reducing is the protocol on democracy and good governance requires member states, requires governments of the member states to respect and observe human rights. And that is why the court does not shun and turn away any complaint that is filed for violation of human rights. The court does not turn anybody back. In fact, the way the court is established, the court receives and hears every complaint brought to it free of cost to the litigant.
Free of
cost. From the day you bring your complaint to the court until the day a decision is rendered. You do not pay 5 cents, you do not pay 1 kobo, 1 naira in the ECOWAS court. Nobody pays any fees. The court absorbs the cost. So when somebody from any member state, let's say from Nigeria, comes to the court and files their complaint, the court takes the responsibility to serve that complaint on the respective government. The court receives the response and sends it to the complainant. The complainant files his response through his lawyer, and it is the court that. So, in other words, ECOWAS has gone one step further to enhance human rights, that they make it free. The only cost the litigant would bear is paying his lawyer. Now, that is why, and in fact, I will go to that before I end this program. That is why, in the protocol on the court has a mandate to provide legal aid. But that legal aid has not been established.
Oh.
Now, what that legal aid means is that it is a forum, it is an opportunity where the court, where ECOWAS will provide free legal services for ECOWAS citizens. But we have not been able to activate that. We have not been able to attract funding to support the funds to provide free legal services to all litigants across member states. So that is one of the shortcomings of the court, even though the court is, we're rendering free services in terms of hearing and determining the cases, but they need to go one step further to provide free legal services to the litigant. So the litigant should now have to pay lawyers.
Oh, and now we've been listening to Justice Micah WilKins Wright. He's the former Vice President of ECOWAS Court of Justice in Abuja. Well, any moment from now, we would allow you to join in the conversation so you can ask a question or two about the workings of ECOWAS as a whole and its Justice Department. Now, what is the ECOWAS Court doing to ensure that basic rights of citizens in the region are protected?
Well, there are two things. One, the primary thing the court does is to adjudicate cases that are brought before it. That's one way to ensure. The second thing is sensitization, public awareness, public education in member states. The court has a program, an annual program, where judges and other staff of the court visit member states to educate the general public, the general citizenry in those member states on the existence of the court to begin with, and the activities of the court. What jurisdiction the court has, what can the court do to help them, and the rest of it. So those are the two ways in which the court can ensure, or ECOWAS can ensure, that citizens of ECOWAS are aware. You see, they have to be taught, they have to be educated that you have rights. And this is how you can enjoy these rights. And if your rights are violated, these are avenues you can ventilate your grievances through ECOWAS, especially if you cannot get redress in your home country. You see, because there are times, and there may be times, or there have been times, when people are aggrieved in their own country, and they are deprived of access to the judiciary of the member states. Say, for example, in Liberia. I'm not going to touch about Nigeria. I will talk about Liberia that I know.
Okay.
Now, if the government, for example, seizes your land and throws you out, and you got no right, you got nowhere to stay, the African Charter provides that every human being has a right to live, a right to life. You have a right to housing, to shelter and protection. So if your home government dispossesses you illegally, they take your land not for a public purpose, they refuse to compensate you, they treat you as if you are nothing, and you go to the court in Liberia, for example, and the judiciary will not hear you, then you need to know, as a citizen of Liberia, that the ECOWAS court is there. You can bring your government to the ECOWAS court to answer for abusing your human rights. So that's just one example. So citizens of West African countries need to be taught, need to be educated, that the ECOWAS court is there as a refuge. When you cannot get justice in your home country, you can come to ECOWAS and you will get justice. And in fact, the ECOWAS Court has gone one step further to say even if you do not file a complaint in your home country, you can still come to ECOWAS without suing in your own country. You do not have to, in international law, we call that the exhaustion of local remedies. That means you must exhaust all the means in your own country, and when you can't find any headway, you come out. But ECOWAS Court has been proactive and have been judicially active, to say judicial activism, by deciding in one of their cases that you do not have to file a case in your home country first. And even if you file a case in your country, while that case is pending, you can still come to ECOWAS and you will get redress. So that's one of the ways in which ECOWAS has tried to reach out to educate people to know that the court is there and that you have access to the court.
Wow. So, sir, can we hear from you on those questions?
All right, thank you very much. Starting with the first question on why there is no university or polytechnic established by ECOWAS. The education of citizens of ECOWAS, in terms of formal education, that is, I would think is a matter for each domestic government to implement. But let me go one step further to say that the court is the institution I work with and I am aware of that engages in outreach. So our public education is in the form of the sensitization missions implemented by the court every year. The court conducts a series of 2 sensitization missions per year, and they rotate, they spread the judges up. For example, at the time I was on the court, we were 7 judges. Okay. So you would take 7 judges, spread them across the 15 countries. So you would do 7 in, let's say, June, and you would do another 7 maybe in October, for example. So that each judge would lead a delegation to a particular member state and do public education. So we have not, ECOWAS has not come to the stage where they can run a university or so, but at least the mass education through the institutions of ECOWAS, I think, is the way to go. Secondly, and I will comment on this toward the end, that's one of the things I want to engage in my retirement. Okay. The other thing is, it is incumbent upon institutions to incorporate studies about ECOWAS in their respective curriculum or syllabus. So, for example, in Liberia, it will be incumbent upon the law school in Liberia, for example, to include a course in community law, or maybe the political science department in Liberia could develop a course outline on regional integration, and that would be a vehicle by which they can teach about ECOWAS and what ECOWAS stands for and the rest of it. That would be the way I would suggest. But I don't see ECOWAS establishing a university to teach about ECOWAS. I would leave that to the member states through their respective institutions. Let me come quickly to the second question about no common currency. Let me just correct this caller, this person. Thank you for the message. But let me just say, and this is part of it also, the court is very active in terms of sensitization. And I think the commission needs to, with no ill will to the commission, no disrespect to the commission. I think they need to do outreach as well, because this common currency is on the front burner in ECOWAS as I speak to you. There has been several moves to establish a common currency for West African states, like how in Europe you have the euro. Now, the ECOWAS Commission is active in all of the member states, trying to forge ahead with adopting a common currency for West African countries. There are challenges, and basically, I would just say, let me just say, this is political in the sense that when we decide to adopt a common currency, that would mean the member states, in a way, will give up some of their sovereignty.
Okay.
Say, for example, as we speak today, the United Kingdom, Great Britain, wants to pull out of the EU. One of the key questions is they want to take control of their money. They want to take control of their currency, the British pound. They don't want to give up that sovereignty to the rest of Europe. So it will come back to the same way in ECOWAS, where member states will be reluctant. And I think, because this has been on for several years now, they've done a lot of feasibility studies. They've had so many meetings, technical meetings, between ministers of finance, central bank governors of the member states, and the rest of it, and the ECOWAS Commission. And to date, they have not come up with a final position. Because why? Members, you have to understand. For example, the French-speaking countries, the Francophone members of ECOWAS, they are already in a currency relationship among themselves, which you call a CFA. So in all of the member states of ECOWAS, the French-speaking countries, you have the CFA. That CFA is tied to the French franc in Paris. Now, those member states are loyal to that
colonial master.
Correct. Now, for them to break that tie with France and come to join the English-speaking countries of West Africa in what they will call the ECO, that is the name of the proposed common currency, the ECO.
The ECO.
For the French countries to break ties with France, give up that CFA, and come and harmonize with the English-speaking countries, Nigeria will have to give up the Naira. Liberia will have to give up the Liberian dollar. Sierra Leone will have to give up the Leone. Guinea will have to give up the CFA, whatever they got there. Silly. And you know, Ghana will have to give up the CD. So all these countries will have to give up their individual currencies and take on what we call the ECO. Now, the greatest challenge, I think, will be with the French-speaking countries. Because in the ECOWAS, you have 15 member states. 8 of them are Francophone. They are French-speaking, 8. 2 are Portuguese. And 5 are English. So if you put those 2 Portuguese and the 5 English, they are still less than the 8 French countries combined. So the French countries will dominate almost all of the time. And so establishing the common currency, I think, is doable, but it's difficult. And
it's doable but difficult.
It's doable, but it's difficult. And I don't see it in the immediate foreseeable future. I don't see it right now. But just to satisfy this caller, there is a move right now, and it's been on for many years in the ECOWAS Commission. Maybe this caller can take up the issue with the ECOWAS Commission. Now, the last question on this was no military high command to enforce peace. Now, I stated earlier that one of the achievements of ECOWAS was established as an economic union. But when the Civil War broke out in Liberia in 1989, President Babangida was in power here.
Yes.
And the Nigerian government moved in, ECOWAS moved in, led by Nigeria, to stop the breakdown of law and order. The international community, led by the UN, was reluctant. And here, I will go on record as a Liberian citizen, not as a judge of the court, but as a West African citizen, as a Liberian citizen, to say thanks to the government of Nigeria. Because when the international community was debating and dragging their feet, and Liberians were killing each other, Nigeria moved in and sent in troops, leading ECOWAS. It was not only Nigeria, but Nigeria took the lead. And Nigeria made a tremendous sacrifice. Nigerians died in Liberia. Nigeria poured a lot of resources into Liberia. Military hardware, trucks, bombs, airplanes, pilots, all kinds of things, including academic teachers went to Liberia. So as a Liberian citizen, I must here publicly acknowledge the role played by Nigeria leading ECOWAS. Other countries participated, but Nigeria played a dominant role. Nigeria paid the greater part of the bill. So, I mean, it's a fact of life, and we have to be grateful for the role played by Nigeria. But let me come to the question. Right now, maybe 2 years ago, 3 years ago, there was a civil war in Mali, and troops had to be deployed from member states. Even Liberia, having benefited from ECOWAS intervention, Liberia contributed troops to that peacekeeping force in Mali. In fact, they are there now. The Liberian contingent is still there. ECOWAS is still in Mali. ECOWAS is in Guinea-Bissau yet. ECOWAS intervened in Liberia, in Sierra Leone, in Ivory Coast, just name it. So we have to give credit to ECOWAS. Now, coming to the question, the reason why they cannot have a military high command, I will leave that to the experts, because there is a commissioner at the ECOWAS Commission in charge of peace and security. All right, I don't know who the commissioner is now, but prior to now, in the last 4 years, that commissioner came from Nigeria. But I don't know who heads it right now, because they rotated seats last December. So I don't know who has that commissioner for peace and security. But they have a department at the commission handling peace and security, and they are the experts and will say why it's not possible or it's not practicable to have a standing arm, because what that will mean is that member states will have to contribute troops. The logistics of implementation, you have to decide which country will host that force. You have to decide which country will donate what, how those troops will be supported. We're already having challenges with member states supporting ECOWAS in total. So to establish a standing military force, it will require funding, it will require logistics, and the details have to be worked out between the member states. So it will have a lot of political implications, and that's why I will refer this caller to the ECOWAS Commission Department on Political Affairs, Peace and Security. I will go to another question.
Here's another message here on our WhatsApp. It says, "Good morning, my respected jurist. Thanks for your service to Africa. Please, is ECOWAS court decisions only of persuasive nature? Has there been any decision of the Court on Human Rights which has been enforced? Why can't the court align itself with ICC and get its decisions enforced by the United Nations?" Charles from Guarimpa sent that message. A quick reminder to you, Justice Micah WilKins Wright, that we have just 3 minutes to go.
All right, thank you. Like I said in my initial talk, one of the greatest challenges facing the ECOWAS court is implementation of its decisions, enforcement, executing the decisions of the court. Now, ECOWAS court, part of the decisions the court can make, part of its mandate, is to render advisory opinions. Yes. For example, the commission can write the court and say, look, we have a challenge. Can you give us a legal opinion on what we should do in such a case? The court has that mandate. The court can do it. But the short answer, the context of that question, my answer to that question will be no. The decisions of ECOWAS court are not merely advisory.
Or persuasive.
It is not persuasive. It is justiciable. That means it can be enforced. It is a legal judgment. It is a valid judgment to be enforced by all member states. Now, like I said earlier, only governments, only member states of ECOWAS can be sued before the ECOWAS court. Member states are the only defendants before the court. So individual citizens cannot sue other individuals. We do not have jurisdiction to hear cases against an individual. If an individual broke down your house, if an individual killed your relative, you can't sue that individual to the ECOWAS court. But if your government dispossesses you, if a government vehicle kills your relative and refuses to give you redress, you can come to the ECOWAS court because it is a conduct of the government.
I want you to quickly address this not aligning to ICC.
All right. The ICC is created by a statute, by a law, by an international agreement where countries from around the world came together and discussed and agreed that in case there are violations in member states, we will have competence to try those cases in before this International Criminal Court. Now, member states have to sign up. It's a treaty. It's a treaty where member states have to agree to become a member or not to become a member. So, for example, as powerful as the great United States is, it's not a member of the ICC. America refused to sign the treaty. They call it the Treaty of Rome. Just how you got the ECOWAS treaty called the Treaty of Lagos. The ICC statute was signed in Rome in 1998. You see? So the Americans, they supported it financially, but they're not a member. They said nobody's going to try American citizens all over the world. America alone will try American citizens. That's their
position.
That's their position. So as much as they support the ICC, they are not a member and they are not bound by the jurisdiction of the court. Now, I said that to say, ECOWAS is established by a treaty where 15 member states, formerly 16, Mauritania withdrew. 16 member states came together in Lagos in 1975 and signed the Treaty of Lagos. Mauritania withdrew, leaving 15. Now, so only member states who agree to be bound by the treaty are members. So, if there are other countries in West Africa that refuse to be members, that did not sign the treaty, you cannot bound them by the ECOWAS provisions. So ECOWAS is an institution only for West Africa. The ICC was established by treaty among countries from all over the world who agreed to be bound by that treaty. So if a country agrees not to be bound by the treaty, then they're not members of the ICC, and the ICC got no jurisdiction in their country. So ICC cannot send, let's say for example, if Nigeria was not a member, but Nigeria is.
Yeah, it is.
But let's say if Nigeria had not signed the Rome Treaty, the ICC could not send somebody to Nigeria to investigate any crime. They don't have that right. And Nigeria has a right to say, yes, you can come, or no, you cannot come. But of course, as we know now, Nigeria is a member, so they will cooperate with the ICC.
Right.
So we cannot tie ECOWAS to the ICC. They are all separate treaties.